As a barrister and a business person with more than 20 years experience, here are 10 golden things that I think you should remember at all times. Not only are these things that I've learned over 20 years or more that have either helped me or hindered me, and I've learned the lesson, but also as a barrister I've seen them trip people up during their cases, and if only they did or did not do that one thing, they might have just won their case. I've seen countless cases where somebody just did something or said something that they really shouldn't have done, and it killed the rest of their case. So I'm splitting these into 5 things that you should never do and 5 things that you should always do. And whilst some of them might appear on the surface to be very similar, there are subtle distinctions, so let's get into it. First of all, looking at these things from the standpoint of some sort of dispute, obviously you're going to have communication with another party. So my first tip is a never tip, and that is never send an email when you're angry or in any other state of emotion or reacting to something out of that emotion. The simple reason being, as obvious as it might sound, is when you are angry or reacting out of emotion, not only obviously will you say things that are heated and perhaps a little bit more aggressive sounding than they really ought to be and that you would ordinarily send on any other occasion, but you might also lose sight of the facts. You might say things that you regret that ultimately trip you up later, because all of these emotions whirling around in your mind are going to cloud the real message that you really want to send. If the message that you want to send is that you are really angry about something, then that doesn't actually help to solve the problem. Whereas if what you really want to say is that the other party is in breach of contract, then that's how it should be said. But either way, if you're saying this whilst you're angry or emotional, it's not going to have the calm, collected, reasoned and measured response that you really need to. Number 2, moving on to the stage where you have drafted an email or a letter. Number 2 is always take a break before actually sending the final email or letter, if the case might be, particularly if this relates to a personal matter to you. Now, many lawyers will agree with this, that once you've drafted up a letter, you've been buried in that document for maybe a few hours or even a few days, depending on how long the letter takes. It's very often a very good idea to leave a break before you actually hit send, because when you come back to the letter later on with a fresh pair of eyes, not only might you pick up typos that the spell checkers didn't pick up before, but you might also just pick up some wording that doesn't really read as clearly as you'd like it to. But in the drafting process, you might convince yourself that this flows perfectly naturally and that there's nothing wrong with it. But when you come back with a fresh pair of eyes later, you might think this really could be drafted very slightly differently and be much clearer. And whilst you're at this drafting, the next one is a never. We're going in alternates. And to alternate back to the never for number 3, in the drafting process, never attack the person directly. Unless, of course, you're in court doing cross-examination of a witness for whom you have permission to adduce bad character, attacking someone's character is never really a good idea. Instead, attack the problem, because the person actually could be going through any kind of personal circumstances and difficulties that you might not be aware of, and they might themselves be reacting out of emotion, which, thinking back to our number 1 in this video, never sending things out of emotion, that's exactly what they might have done. So if they've attacked you, your natural reaction might be to attack them in response. But as I say, that's not going to solve the problem. Countless times we see these email correspondence, even from some law firms with respect to them, attacking the people inside of the argument rather than the problem itself. And that might result in voluminous paperwork and exchanges and correspondence, all when it's a very simple issue that when we eventually get to court, it's a very straightforward and an emotionless issue for the court to decide. So ultimately, attacking the person is, I suggest, not going to solve your problem, whereas attacking the problem and addressing the problem is much more likely to produce effective results. Number 4, switching back to an always tip and sticking with the subject matter of drafting, always write something with the knowledge that it might someday be read by someone else, and better yet, even a judge. If for every piece of correspondence you draft, You imagine a judge reading it and then looking up over the bench at you across the courtroom. What is it you think the judge is going to think of you having read that correspondence? Because if it puts you in a bad light or damages your credibility somewhat, that is obviously not going to do your case any favours. One frequent such occurrence in the courtroom is where parties have had these heated exchanges resulting in threats and intimidation. In one such exchange, one party sent various text messages to the other, making unfounded and untrue allegations, with the tail-off comment at the end, and I quote, "I will tell the court this happened, and that won't look good in court, will it?" So obviously all of these lies being repeated back to the sender of these messages in cross-examination, pointing out the fact that all of these were lies, followed up with the comment that we are in court and it doesn't look very good, does it? This obviously didn't put the sender of those messages in best favour with the judge. Building on number 3 and 4, number 5 is a never, which is never make threats. For the same reason as in number 3 and 4, making threats doesn't really look good and can only serve to make you look bad. Unless, of course, you're making a legitimate threat, for example, the threat of legal proceedings in a case where someone hasn't complied with the terms or reasonable demands of those terms, which has a foundation in law and within an appropriate time frame. But you can't also round that off with any other kind of threat. You can't, for example, say comply with the terms of the contract and pay me this amount of money, or we're going to send someone around, because obviously that is a different type of threat and that is just not acceptable. An interesting tangent here is that whilst most communication is deemed to be without prejudice if it's a genuine attempt to resolve the issues between the parties, if you throw in a little threat there at the end, that can remove the without prejudice tag and the letter can then be produced in court, whereas otherwise it would remain private until the very end of a trial. You should also be careful that there isn't a statutory provision that makes the making of your threat unlawful. For example, if you watched my previous video for unjustified threats of trademark infringement, that's where someone has a registered trademark but is then weaponizing it against another party who hasn't infringed their trademark, but they are alleging that they have, even though they haven't specified how they say they have or that they might by attaching that trademark to goods or services, which would amount to trademark infringement. In the event that they haven't, it's an unjustified threat, and that gives rise to a cause of action by the aggrieved party for damages and potentially an injunction against the maker of the threat, to prohibit them from continuing to make that threat and for any damages which arise. Moving on to evidence for number 6, you should always keep the evidence of anything you might want to prove in court in a safe place. It's amazing how many cases fall because they simply don't have the evidence. In what might otherwise be a very firm case, if you don't have the evidence, then the court simply cannot invent it. If you don't have the evidence to prove the point that you're making, then the court is not likely to accept it. Although the court can balance all the rest of the evidence and the witness statements on the balance of probabilities to decide whether or not something happened, saying that something occurred without any evidence is simply quite difficult. For example, if someone says that they were in a particular time at a certain place, and let's say that this was in a different country, then anyone would expect to see travel tickets, bank statements to prove that they paid for those tickets, travelling abroad, or anything else that could show that they were in fact there. If you can't find any of that evidence, then on the balance of probabilities, it's more likely that you weren't in that other place. But even for things that you might think are initially quite trivial, such as parking receipts. So many people get parking charge notices and penalty charge notices, there's a distinct difference between the two, and they simply cannot find the parking receipt even if they've actually paid for it. And the terms of the ticket are alleging various infringements on the terms of parking, none of which you'll be in a position to prove unless you've saved the evidence. This is so important that I've even worked with a developer to produce an app called Proofify to store your evidence in a safe place. The common rebuttal to this app is we can just take photos and store them on our iCloud or wherever. But I promise you, if you keep all of the evidence in one place, such as our app, Proofify, check it out, it's linked in the description below, it is so much easier for you to then pull up the evidence you want if ever you need it. Moving on to terms and conditions for number 7 and 8. Number 7 is never sign something without reading it first. Now, of course, if something is outright unfair, then it's likely to be unenforceable anyway. But the small print is going to be binding unless it's unclear and unless it's unfair. But the law is not going to protect you from a bad deal, especially if you've signed it. Now, all of these terms and conditions will have to comply with the law. They have to be sufficiently specific and certain, and they have to be fair and in accordance with the law. For example, you can't sue someone on a contract when the underlying principle of the contract is illegal. For example, a drug dealer couldn't sue somebody for not paying for the drugs under contract law when the sale of that thing was illegal in the first place. But if you sign something that has terms and conditions attached, you're going to be bound by those terms and conditions unless the law says otherwise. A very subtle distinction for number 8 is always read the terms and conditions. Now, the difference between 7 and 8 is that you're not always asked to sign the terms and conditions. For example, if you're on a website and you buy something, the process of buying it binds you to those terms and conditions. Now, some people will mistakenly, with respect, believe that the terms and conditions don't apply to you unless you've signed them just because you bought something from their website. But that is not true, because every website and every shop will have a set of terms and conditions that will bind you in the event that you buy something, and unless, as I've said before, it's unfair or unlawful. But otherwise, those terms are going to apply to you. And if you don't like the terms and conditions, then you shouldn't enter the contract. For example, there are various rules on returning something and who pays for the shipping. I've covered that in other videos. But unless you read the terms and conditions, you won't know what they say. Of course, in consumer law, there are both statutory and regulatory requirements for all contracts to adhere to. But this applies not just to consumer, but to businesses as well. If you don't read those terms and conditions, then you won't know what they say, and you're more than likely going to be bound by them. Now, sometimes between businesses, we have what we call the battle of the forms, which essentially means both businesses or both parties have their standard set of terms and conditions, and there's an argument as to which one applies. Now, there are volumes upon volumes of law books that deal with how contracts disputes are to be determined by a court depending on the terms within those contracts. But if you haven't read the terms and conditions from the first place, you're starting on the back foot. Number 9 is a tip that often comes about with road traffic collisions, which is never verbally admit liability, especially out of shock. Now, whilst particularly in road traffic cases, judges are usually very wise to res geste comments, which are those comments made whilst being emotionally overpowered by an event, it is still better not to admit anything unless and until you've taken formal legal advice, it is done properly within the bounds of the law, and usually it's to ring-fence your risk of costs arguing an issue which ultimately you're likely to lose. For example, if you're invited to admit the fact that you were on a given road at a given time and date, then you might as well admit that in the right circumstances, because arguing over that point, whereas ultimately it will be proved that you were there, might indeed land you with a hefty costs bill. For example, if you spend a day in court arguing over the fact that you were there, and the court determines that you were there, but you refuse to admit so a year and a half beforehand. But otherwise, and unless you've taken formal legal advice, it's never a good idea to verbally admit something unless you've been given that advice. Now, taking this to the police station, for example, if you are in shock and you're being questioned at the police station, it is not an admission of guilt to seek formal legal advice before admitting to anything. Because even if you do admit certain things at the police station, it is still better that you do so with the benefit of legal advice. Because the way in which you phrase it is obviously, I would hope, going to be better once you've had the advice from a lawyer than it would be if you just say it out of shock and horror that you're being questioned at the police station. And finally, at number 10, speaking of things spoken, always keep a record of everything said by you or other parties, when and where. Because if later on in court you want to say that Mr. or Mrs. or Ms. X said a thing, you might need to be able to prove that they said it. Now, many people will say and believe that if it's not written down, it didn't happen, but that, of course, is not really true. So long as the court accepts your evidence that a certain person said a thing at a certain time and place, then that will become a finding of fact by the court. For example, if you go into a shop and they verbally agree with you that you can return a product if you don't like it, and then indeed if this was a gift and the recipient doesn't like it and you're back at the shop trying to return it and the shop says no, then you can indeed enforce that term in court that you could return it if they didn't like it if the shop refuses to take it back. but only if the court accepts as a finding of fact that you agreed that verbally with the shopkeeper. And before the keyboard warriors arrive and say this will never hold up in court and a judge will never accept such a thing, I am speaking directly from trial experience where the judge has ruled that the conversation took place, the agreement was made, this was a gift for the person's significant other, and they returned to the store to exchange it for something else because they didn't like it. It just didn't suit their needs. Now, whilst the fairly prestigious retailer argued tooth and nail to the tune of about £9,500 that they were not going to get back because this was a small claim, the judge found that this conversation took place, the shop was wrong, they were never going to get those costs back in any event, and my client obviously won the case. And that is why you should always make a habit of keeping records of everything done and said in case you want to refer to it later. That is why lawyers make attendance notes of every conversation, every conference, and every court hearing or trial that we attend, and police keep pocket notebooks of every incident that they attend, because 2 weeks from now, most people will have no real clue as to exactly what was said, and certainly not with any concrete specificity of what a person said during that conference or during that trial, unless it's written down and recorded somewhere. Trust me, most people think that they will have the memory to recall this conversation in perfect clarity. But given how quickly some people crumble during cross-examination when trying to recall a certain event, and they are tripped up by various inconsistencies in their story or something that they've said later, which we refer to as a previous inconsistent statement, i.e. they've said something different beforehand to what they are now saying in court, my suggestion to you is that you are always better to write things down contemporaneously at the time. But just bear in mind that this might then be seen as a self-serving statement. For example, you can't write down, I would never have the intention to go out and steal a car, and then go out and steal a car and try to rely on your note from earlier to prove that you would never have stolen a car. Those are self-serving statements, and those are not what I'm talking about. But I hope you found all of these tips useful. If you do, please like the video and subscribe for more content. Thank you very much for watching, and I will see you next time.